Welcome to Notable Approvals. I am attorney Amanda Shaffer. Before we get to our case today, just a quick note. Today, of course, is Martin Luther King Day. And in observance of Martin Luther King Day, we think that it is a great time to reflect on Dr. King's legacy of nonviolence, especially in light of the attack on our Capitol on January 6th. This country became great not because of violence, but because of nonviolence. And people riot when they feel they're not being heard or that they're being wronged, whether they're right or not. But to all those out there that are feeling that way, I would suggest you take a look at the civil rights movement and see what people back then were facing. Yet even in the face of water hoses and beatings and everything horrible imaginable, they still chose the path of nonviolence. So that's my little 2 cents on Martin Luther King Day. If you have the day off, I hope you have a good day off, and that, think about and spread some helpful information about fighting racial injustice, because we still have a long way to go. Now, before we get to our case, one more thing. Don't forget to like us and follow us on Facebook and YouTube, Twitter, Instagram, LinkedIn, all of that good stuff. Now we're ready for our case. So today's case is about a client who is a native and citizen of Indonesia. She initially entered the U.S. back in May of 2019 with a B2 visitor visa. She married her lawful permanent resident husband, who is from Morocco, about 3+ months after she entered the U.S. So if you saw my notable approval where I discussed the non-immigrant intent issue with marrying too soon after you enter the country, this is a good example of somebody who did not marry within the 90 days. So by marrying outside of the 90 days, we didn't really have that problem. But we had a couple of things that we had to take into consideration. Number one, we had to make sure the visa number is current, because if the visa number wasn't current, then she couldn't adjust her status because her spouse was not a U.S. citizen. He's a lawful permanent resident. So she would have had to leave the U.S. before she wouldn't be able to stay. Unlike someone who marries a U.S. citizen, she wouldn't have been able to stay in the U.S. while the application is pending, because she would have gone out of status. She wouldn't have been able to file the I-485 until the visa number was available, which means she would have gone out of status and then wouldn't have been eligible for a green card without a waiver. So there's a very big difference between marrying a U.S. citizen and marrying a permanent resident in this respect, and several others. So that meant we had a 6-month window with which that we could file for her green card. Obviously, they had to get married first. I don't believe this was planned in advance of her coming to the U.S., but we didn't interact with her right away, of course. But when she came to us, they were just about to get married. And we told her, well, you guys better start getting everything together quickly, because, you have 6 months from when you entered. And if it's even a day late, we might have a problem. So we didn't have a problem getting out on time. That was good news. The second issue that we had was after we filed it. Now, this was one of those filings where you can't risk getting a denial, a wrongful denial, because there's no appeals, and because then she's out of status and she has to leave the country. So we had to make sure everything was perfect. And as we do with every client, but we always have to have a special eye on situations like this where you get one shot. And we got a request for evidence a few months after we filed. And of course, this was a request for evidence that they probably should not have sent this request for evidence. Essentially, they asked for proof of her husband's U.S. citizenship, which we clearly stated he was a permanent resident, and gave a copy of the back and front of his permanent resident card. It then had a problem with the birth certificate that we submitted, saying that it wasn't it didn't come from the appropriate authority. So we had to go get a second birth certificate, even though the first birth certificate was a legitimate birth certificate. And I've talked about these requests for evidence before and how we've had a client come to us after a denial because he got a request for evidence and looked at it and said, this doesn't apply to me, or I already sent this, so I'm just not going to respond. And this is a good example of one where we had literally already sent one of those things. The other one was irrelevant. However, that is not, we did not ignore it by any means. We did have her go get another birth certificate. We had to, like double check the authorities, depending on where you're from, which country and where in the country you're from. Sometimes like birth certificates are not always uniform. And in Indonesia, in certain parts, I guess it might have been a long form, short form issue. I don't remember exactly. But bottom line is, no matter what, we looked at the requirements. We got something else that looked like it met the requirements. We didn't ignore it. Now, as for proof of his U.S. citizenship, the way we handled that is I wrote a cover letter explaining that we said that she's in category F2A, which is spouse of a permanent resident. Her spouse is a permanent resident. We submitted a copy of the card. We submitted a second copy of the card with the response to the request for evidence. And then I don't know if that shows on my live, I hope not. Then we, sorry, I just got a text that popped up on my screen. That's why I got distracted. Then we also put in evidence of her lawful status because, as I said, that's Aaron. Give me one. Let me let Aaron know that I can't talk right now. Anyways, sorry about that. That's what happens when you go live, I guess. So we also put in evidence of her lawful status. Even though we had already done that with the package initially, but again, we still did it again. We put in her I-94, her visa, her stamp, and then we also put in a copy as we did with the initial petition of the visa bulletin to show that the number was current. And then finally, the new birth certificate we put in. So that satisfied USCIS, and they finally scheduled her interview. And her husband went, and the I-130 was easily approved. But then we had a problem because she went, as you know, if you've gone through this process, you need to get cleared by a doctor. You need a medical examination. It's the form I-693. And every permanent resident is required to have gone through this medical exam, either if they came in the country as a green card holder in their back home or here. And this client, she got her medical exam, gave it to USCIS, and they said, well, we can't approve this. You didn't get your vaccines. The reason she didn't get the vaccines is because she had a condition that the doctor said it is against medical advice to give you this vaccine. I'm not giving it to you. But USCIS didn't care because the condition that she had was not on their list of conditions that are exceptions to the vaccine requirement. So what do you do now? Well, we then sent her to other doctors, like other USCIS civil surgeons, I think about 3 or 4 of them. And she told them the situation, and all of them said the same thing. No, I'm not giving you the vaccine. It's not advised. And they all completed medical exams for her. We submitted all of those medical exams where the doctor said, look, I don't care if it's not on the list. This goes against medical advice. I'm not doing it. And fortunately, with all of that, it did satisfy USCIS. So our client was finally approved for her green card. And of course, they have been married for less than 2 years. So she did receive a conditional green card, and she will have to file for her the petition to remove conditions on residency for a 10-year green card the 3 months before the 2-year anniversary of having her green card. So it just shows you sometimes that, again, you have to be very careful when you're dealing with a situation that you only get one shot at filing it, because if it gets denied, the lack of status becomes a problem. You always respond to requests for evidence, even when they're asking for things that are irrelevant and that you've already submitted. And if you go to the doctor and they say, I'm not giving you a vaccine because it's against medical advice because of a condition you have, well, don't let USCIS tell you that you can't get a green card. There are ways to protect yourself. And if you need any help filing for your green card or any other immigration matters, our contact information has been scrolling across the bottom of your screen. Do not hesitate to contact us. That is all today for Notable Approvals. Thank you all for watching and have a great day.